Hey guys, welcome to my channel. In today's video, two emotional courtroom hearings reveal how family judges handle some of the most difficult decisions involving domestic violence, child safety, and protective orders. From a mother seeking sole custody after alleged abuse to another parent asking the court for protection from her own daughter, every testimony shapes the judge's ruling. Stay with us until the end to see how the court balances evidence, safety, and the law in these deeply personal cases.
Just a little background for the court. Mr. Hartigan filed an answer. He had an attorney, J.P. Bradley. Mr. Bradley withdrew right after filing the complaint.
You, Mr. Patrick.
And we, Mr. Hartigan, than ever.
Mr. Patrick, you are frozen. I don't know if it's apparently maybe having to do with your internet connection. Could you repeat what you just said?
Indeed, Your Honor. Can you hear me now?
I can hear you.
Okay. Mr. Hartigan was previously represented by J.P. Bradley. He withdrew almost immediately. We have not seen him since. And he's not responded to anything we have sent him or anything else throughout the whole proceedings.
All right. Put on your coat. If you are, let me ask this. Anyone who is on screen with us that is not involved in this hearing, please mute your device so that we don't have any crosstalk. If you're on screen and you have a hearing in this court that is not involving a Hartigan case, mute your device. Mute anyone who's not already muting them. Thank you. All right, now we're ready.
All right.
Ms. Hartigan.
Sorry, Ron. Ms. Hartigan, you and Mr. Hartigan have 4 children together. Is that correct?
Yes.
And these are all preschool age children. Is that correct?
Correct.
You do not work, do you?
No, sir.
And why is that?
Because I can't afford to provide them with child care services.
Okay. Are you trying to tell us that 4 children preschool age take up a lot of time?
They do.
All right. And you filed this divorce in August of this year. Is that correct?
Yes.
And you filed it just after an order of protection was granted for you against Mr. Hartigan. Is that correct?
That's correct.
And you're alleging cruel and inhumane treatment or abuse in your complaint for grounds. Is that correct?
Correct.
When the events of the order of protection that Judge Lockhart granted for you, briefly describe them to us and tell us who was in the house at the time.
At the time, all 3 of my children were in the house. My youngest was asleep. My 2 older children were having a snack. And my hopefully soon-to-be ex-husband, Anthony Hartigan, came to our residence and physically assaulted me in front of my 2 older children.
Were you pregnant at the time, ma'am?
No. And
I didn't hear you.
what was the question?
Were you with child at the time, pregnant at the time?
No, I wasn't. My youngest was just taking a nap.
I got you. But you said there were 3 children in the house and you have 4?
No, Anthony and I have 3 children, Gage, Arabella, and Adeline Hartigan.
All right, my mistake. Thank you. All right. And Judge Lockhart ordered no visitation for him, Mr. Hartigan, did she?
Correct.
Matter of fact, she said he won't have any until he petitions the court. Isn't that correct?
Correct.
And how, go ahead. Did you say something after that?
No, sir.
All right. And how long have you and Mr. Hartigan been apart? Weeks, months, what?
At the time of the order of protection, we had been apart for roughly about 6 to 8 months.
Okay. Does he have any bond at all with the children?
Not at all. No, sir.
Okay. And is it your desire that he be given no visitation or only therapeutic visitation?
That is correct. No visitation if that's possible.
And has he made other threats against you other than the order of protection events?
He has not contacted me after the order of protection. I haven't had any contact.
But he's made threats to you other than the events of the order of protection?
Yes, absolutely. Yes, before that, there were absolutely verbal and physical threats.
Okay. And has he also threatened the children?
He has only verbally threatened my oldest child, who's my son, Gage.
Okay. Do you take these threats seriously?
Absolutely.
Okay.
So Patrick, let me interrupt you and ask this question. I noticed in reviewing the file that there was a motion, before Mr. Bradley withdrew, there was a motion for specific visitation that I think Mr. Hardigan was attempting to address the issue of trying to have some sort of visitation. I noticed you filed a motion to strike, basically alleging that it was an attempt to run around the order that Judge Lockhart Masher put down for no visitation with Mr. Hardigan. Did that motion ever get heard?
He didn't show for it, Your Honor, and I'm not. It was given a date when Mr. Bradley withdrew, but was it ever heard?
Well, you were present, and the judge, I guess, denied it since he didn't show.
I think the judge denied his motion since he didn't show.
All right.
That's what my paralegal's telling me. She was there as well. Now, daycare. Have you looked into what daycare for 3 preschool age children would cost you?
I have. There is a daycare that I just looked at the prices of. It's called the Goddard preschool, and for my son, it would be about $1,800 a month, and then for my 2 girls, it would be about $1,200 a month for each of them.
I'm sorry, this is what now? What is it?
Child care expense, Your Honor.
$1,800 a month for childcare?
Yes.
For 3 children.
$1,800.
Yes, sir.
And where is this $1,800? Where is that being spent?
Oh, no, I'm not spending that. I looked at childcare at the Goddard School here in Mount Juliet, and that was just the price for what it would cost to send my son to that particular school.
So that's the actual cost of school?
Correct.
A tuition cost rather than a childcare cost, correct?
Well, it's the Goddard School, so I'm not really sure what their specific programs are considered, but it is a daycare / pre-K, and my son's just not quite old enough to go to public school.
Well, my only concern is that it seems to me to be a very expensive. Most of the time, childcare is far less than almost $2,000 a month for childcare, and when we're talking about calculating child support, certainly work-related child care is a part of that, and it is a factor to be considered, but my concern is trying to make sure that there's some sort of accurate information presented to the court about what's actually the work-related child care. And that just seems to me to be excessive for what I know in all of the other cases that I deal with, so that's why I was asking the question.
Okay.
Are you actually paying child care right now? You're not working, is that correct?
Sir, I'm not paying anything for childcare. I'm a 100% full-time stay-at-home mom.
And that would
Your Honor, the reason.
Go ahead, Mr. Patrick.
Your Honor, the reason the question was asked was when we suggest that she be imputed at 0 income because, it's already previously been ruled that she would be given credit for child care, but she can't afford to have a job and pay for 3 preschool age children, which yes, she'd be imputed at 0. And I just ran the calculations, Your Honor. 3 children, $125 a week.
Well, I understand, and I wanted to clarify that if you were asking that I set the child support based upon a work-related child care of that amount, then I had an issue. But I understand what you're saying is that just establishes why she's not able to work outside the home. So I don't have any problem. I don't have any problem with being able to, or setting a child support order that shows she has no income and that she's justifiably not employed, so that because of the cost of care that would be required. So we'll go forward from that. All right. So if I understand correctly, Ms. Hartigan, you're asking that he not have any sort of visitation with his children. Is that correct?
Correct.
And he has not had any visitation with them for how long now?
The last time that he physically saw our children was July 31st of last year, and that was when the physical assault happened prior to me getting the temporary order of protection. And
he's not made any other effort to contact you or through an attorney or anyone else to set up any visitation. Is that correct?
Yes.
All right. And then under the circumstances, go ahead, Mr. Patrick. I didn't mean to cut you off, but I just wanted to make sure I understood what she was asking.
Ms. Hartigan, now, what do you want to do about your name? Do you wish to return to your maiden name or no?
Yes, sir, I do. I would like to have my name returned to Georgia Jacqueline Steen.
Okay. And are you wishing the court to enter a restraining order keeping this man away from you and the kids?
Yes.
All right. And lastly, Your Honor, we'd request reasonable attorney fees be awarded to the egregious acts of this defendant.
There's no property?
There was no property owned by both of us.
All right. Based upon the fact that there is no response by Mr. Hartigan and he has failed to appear after being given notice of this hearing, then the court has little choice but to grant the divorce to Mrs. Hartigan. She is awarded any personal property in her possession, which basically there's no joint marital property according to what I'm told. She will be designated the primary residential parent. Mr. Hartigan's visitation with the minor children will simply be reserved. And what that means is he has no right to see the children right now. If he wants to see the children, he will have to come into court, which he's failed to do, but he'll have to file something in court and come into court to be able to see the children. Now, that also gives you the right, if you choose, to allow him to see the children, but it's not something that is a court order. So if things calm down and you and he cooperate, and you will allow him to see the children, which seems unlikely, I realize. But if that were to happen, then you have the right to allow that, but you're not required to until he petitions the court and asks for specific visitation with the children.
Okay.
Child support, did you have a dollar amount for his income that I may have missed it? I'm sorry.
I think it was around $2,000. Is what I put on my initial paperwork with Mr. Patrick. Now, what he's making per month right now, I have no idea.
So we'll base the child support on his last known income, Mr. Patrick, with 0 days for the father and no income for her. His income will be what was established at the prior hearing before Judge Lockhart-Nash.
Okay, I want to clarify. Mr. Hartigan, did you say $2,000 a month?
I think so, yes. I think okay. On my original paperwork with you.
All right. His income will be set at $2,000 a month. There will not be any child care in the child support worksheet simply because she's unemployed and a stay-at-home mom. When I say unemployed, being a stay-at-home mom is a full-time employment. I don't mean to say that you're not working outside the home with an outside income. So it's understandable, justifiable, and so forth, but we won't calculate any sort of income for you.
Okay.
Probably needs to put in the final decree, Mr. Patrick, that the court finds that she is justifiably unemployed outside of the home.
Okay. And attorney fees, Your Honor?
If you submit your affidavit along with your final decree, then I will approve the attorney's fees once I've reviewed your affidavit.
Understood, Your Honor. And lastly, the restraining order to keep him away.
The restraining, there was an order of protection that was issued. That's not really before me, but I can issue a restraining order that you can be made permanent under the final decree that he is restrained and prohibited from contacting her or the minor children pending further orders of this court, and that requires him to have to petition the court to come into court and have a court hear the evidence and decide what contact he has with the minor children. He has every right to see the children, and it may be that that has to be under some sort of supervision. So I'm not terminating his right to see the children. I'm just reserving it so that we can have a hearing whenever he decides he wants to see these children. He'll have to file a petition and bring that before the court.
Understood. Thank you, Your Honor.
That will conclude the hearing in the Hartigan case. Let me ask, is there, you have filed a petition for an order of protection against the Mackenzie Johnson. Is
Yes,
Mackenzie Johnson in the hearing? Do we have anything regarding her?
Has she joined? I didn't understand the question. I don't know where she's at.
She was served on 9/29.
All right, Ms. Dawson, you were seeking an order of protection against this individual, and basically indicate that you and she, is this a domestic relationship between the two of you?
Well, she's my daughter, yeah, and she just, I think she's doing drugs, and I don't feel safe at all with her in my house.
All right, well, let me place you under oath so you can testify about this.
Okay.
Raise your right hand. Let me place you under oath, please. Now, you are not driving, correct, at the moment?
Oh, no, sir, I'm sitting not.
All right. You solemnly swear from the testimony you're about to give in this case is the truth and nothing but the truth, so help you God.
Yes, sir.
All right, thank you. And you did affirm that you are not, I know you're in your car, but you're stopped stationary, you're not driving, correct?
No, sir. I'm just,
Right. Thank you. You can put your hand down now. You filed a petition for an order of protection in which you're seeking to have an order of protection against your daughter, Mackenzie Johnson. Can you tell me why you believe that that's necessary? There was a temporary order issued, and all I need to know is why you believe that it's necessary to extend it and how long you're asking for it to be extended.
I think she's doing drugs, methamphetamine, and her whole she's just totally changed. She's become very, she put Nair in my shampoo bottle. She's just very angry.
You had indicated in your petition, though, that there was some violent episodes, something that had happened that you felt like led you to have to get the order. Can you tell me what it was that happened?
When I got home, she had took the lock off of my bedroom door, and I just told her that was, to me, vandalism of my own home. And when I told her that I was going to call the law, she just rammed at me with the front door. I mean, she's never really done that. Just mouthed off and, said very ugly, hateful things. But,
right. And you feel like because of her drug use and the violence that's happened before, that there's a likelihood that it might happen again?
Oh, yes, sir.
And you understand, by issuing an order of protection, I'm essentially ordering her to stay away from you.
Okay.
I have no contact with you. Do you understand that?
Yes, sir. And
this is your daughter that I'm going to be ordering that she cannot have contact with you.
Yeah, I just don't want her at my house. Nothing, nowhere on my property, which she does have 2 of my grandsons.
And you understand that she, and I'm going to issue this based on what you told me, but I want to make sure you understand how this works. It's not a selective situation where I can say she has to stay away from your home. I have to prohibit her from having contact with you, period. So that means that she can't have contact with you, come around your home, can't have contact with you out in public or anything else. Is that what you want?
Yes, that is.
All right. Then I will issue the restraining order, the ex parte restraining order of protection. I apologize. That ex parte, which means that it was issued without a other party being present for a hearing, will be extended for 1 year. And I'll have to fill that out and send it to the clerk, but a copy of it will be available for you at the clerk's office. All right?
Yes, sir.
All right. Thank you. That will conclude your part of this hearing.
Thank you very much. Have a good day.
These hearings demonstrate the difficult responsibility family courts face when allegations of abuse, threats, and family conflict require immediate legal intervention. In the first case, the judge considered testimony describing domestic violence, the father's absence from the proceedings, and the mother's role as the sole caregiver for 3 young children. After reviewing the evidence, the court granted the divorce, restored the mother's maiden name, awarded her primary custody, calculated child support based on the father's last known income, and ruled that the father would have no visitation unless he later returned to court and proved that contact with the children would be appropriate. The judge also entered a permanent restraining order prohibiting contact until further court review. In the second hearing, the court addressed a mother's request for protection from her adult daughter after describing escalating threats, alleged drug use, and a frightening confrontation inside her home. Although recognizing the seriousness of ordering family members to remain apart, the judge concluded that the evidence justified extending the order of protection for 1 year to help ensure the petitioner's safety. Together, these cases illustrate that family courts are guided not only by legal procedures but also by the need to protect vulnerable individuals while preserving due process for everyone involved. Every decision reflects a careful balance between personal rights, credible testimony, and the long-term welfare of families affected by conflict. If you enjoyed this video, don't forget to like, comment, and subscribe. Thanks for watching, and I'll see you in the next video.